outcome. We were hoping to have this event over a year ago as a book launch. But I'm delighted at least that we're having it now, even if it's still not in person. And we have this opportunity to have an exceptional high-level panel of individuals who were at the center of this trial of Hissène Habré. I'm going to mainly just keep us on time and limit my intervention to a minimum. For our audience today, if you have questions, you can enter them in through the Q&A function, and we will take some of them at the end. I'm going to introduce each panelist at their time to speak so that you remember who they are. And thank you all again very much for joining us today. Sharon Weill, I'm going to start with you. Sharon is an assistant professor of international law at the American University of Paris and also Sciences Po. She has extensive experience as a jurist and researcher on immigration and terrorism trials in France and around the world, and is the co-editor of the book that brings us together today. Sharon, take it away, please. Thank you.
Yeah, thank you so much, Sarah. And as you said, we've been in touch for so long to present this book and this panel. So I'm really happy that it's finally happening, even if it's only by Zoom. Last time that I was in Columbia University was in the launch conference of Trial Watch, which was so exciting. So I'm really looking forward meeting again in person when it will be possible. So thank you so much for this, and thank you for the panelists that agreed for this meeting, for this presentation. So I'm Sharon, and I'm going in my 7 minutes to do the impossible and try to present the book and how we made it. So for this, I will also try to oh, I wanted to share my screen, but I see it's not possible. Okay, never mind. I won't share my screen. Is it possible? Yeah, okay. So here we go. Okay, so here is our book, The President of Trial, Prosecuting Hissène Habré. And this adventure started in 2015. I mean, our adventure as the editor of the book, with the meeting of the 3 editors at Berkeley University. And then we had a project to do a collaboration with students of Paris, of Sciences Po and Berkeley. And we wanted to go and to do some empirical research, some interview in Senegal, where the trial took place. So we are in 2000, and when we started, we get the finance and we started the project. We were already in 2016, in between the trial of first instance and the appeal. So I won't get into the detail of Habré and his responsibility, because really I don't have time and you will need to go to read the book. So he was the former president of Chad, prosecuting for war crimes, crimes against humanity. The entire saga of this trial took a very long time and place. So if you can see of the map, you can see all the different, actually, the different places where the victim and the lawyers tried to do the trial, until the decision to create it within the Senegalese jurisdiction as a hybrid tribunal. So now, so we are here. Voila. So we, with the students, went to Dakar, and you can see we did many interviews. What was interesting was that we did many interviews of different kind of actors. So we met the lawyers, we met the judges, we met a politician, even the former prime minister that was in charge. But we met also the Bar Association, also journalists, also donors. So we met an entire variety of actors, not necessarily the one that were inside the court, but more broadly, the different actors that could make it happen. And then we get back to Paris, to Berkeley, each one to its university. And we were thinking, what are we going to do with all this empirics, all this rich testimony that we got, this high professionalism? You know, it was just an amazing and rich material that we had. So one option was to write a book. But then we were thinking that if we are going to write the book, it will be a lot about our input, our impression, and we really wanted to bring Dakar to the world. So our idea was to create a kind of a new methodology and to create a book. So we did it in two parts. When the first part will be the entire trial directly told by its actor. So in the first part, we have 26 chapters that were all written by all the actors. They all agree to play the game. So it's quite short chapters of 4 or 5 pages. And here we have the story from the 90s until the end of the trial. So it's divided into 4 sections. We have the early attempts. There we can have the discovery of the archive. Here you can see by Human Rights Watch. We have a chapter of the president of the Truth Commission from Chad. We have and so on. So we have many other parts from this period. The first defense lawyer at this time, and we have even extract of Habré's last interview. So we put him as an actor. Then the second part will be the establishment of the court. So we have someone from the African Union speaking how the court was created, finally the hybrid court. We have someone speaking about his arrest, the investigative judge speaking about the investigation. Here you have a photo on the investigation in Chad. Who else? This was in the second part. Then in the third part, you have the trial itself. So you will have the prosecutor that wrote a chapter, the judge trial, the appeal judges. You have also clerks, also the administrator of the court. So they were dealing how they will deal with budget. This is about the trial. And then beyond the courtroom, we will have journalists, we will have donors, the Swiss donors, we have academia that academia is partner, because we had the Law University in Canada, in Laval University, that was providing training. Voila. So we have all those different actors that provide a chapter, and we could establish the entire story of this trial through their own testimony. So as you can see, it's a very, very rich empirical material. And in fact, in this way, our aim was also to show that the trial is a long process. It's not, many times in law faculties, you only learn the decision and this is it, outside of its context, outside of its process, outside of its actors and institutions. And here we wanted to show, on the one hand, the long way, but also to show that a decision is like an orchestra. You know, it's like doing music. You have many players that produce this final music, and it's not one judge or one prosecutor. It's this inertia of many actors. And then the second part of the chapter, here we have 18 chapters. It is the academic part. So we ask from 18 academics and experts to provide their reflection about the trial. And after, when we got all these 18 chapters, so we kind of arranged them against these 4 subsections. One was the paradigms. The second was about the institution and the norms, more a positivistic point of view. Then the third one was about the actors, and finally the politics of this court. Voila. So I don't know, Sarah, am I over of time? Am I good? Do I have...
You are just slightly over, and yet I could.
Okay, so I will finish here. So I will finish here. Thank you, Sarah.
Thank you so much, Sharon, and thank you just for really whetting the appetite. As I know I've told you, we use your book in our human rights clinic here at Columbia. It's just fantastic introduction to the topic, and so many diverse voices represented. So looking forward to hear more from you in the Q&A. We'll turn next to Delphine Djiraibe, who is the chief attorney at the Public Interest Law Center in Chad, which she founded. She also founded the Chadian Association for the Promotion and Defense of Human Rights. She is one of the lawyers who initiated initiated the prosecution against Habré, and she's also continued to play a leading role in human rights litigation in Chad. So take it away. Thank you. Delphine, I think you're still muted.
Could you hear me?
Perfect,
Okay.
thank you.
Okay, thank you very much, Sarah, for inviting me, and congratulations to Sharon for the book. It gives a good background of what the prosecution of Hissène Habré was. So I would just add to that background that Hissène Habré was a bloodthirsty dictator. Repression was his mode of government. He inspired terror. No one in Chad could imagine that such a strong and powerful president could be brought before the court. Thanks to the temerity of victims and the lawyers and human rights organizations that support the prosecution, Hissène Habré was judged and sentenced into prison life in 2017 before the extraordinary chambers in Dakar. There are some controversies around the case in Chad, and obstacles have been created by the government of Chad, but the process was a success thanks to the spirit of discipline, sacrifices, and skills developed by the team of lawyers acting on behalf of victims. You know that on the 24th of August, Hissène Habré died in prison. And this death has awakened certain velocity of his supporters asking for his rehabilitation, while victims are still awaiting for their compensation. The conviction of Hissène Habré is a great first in Chad and in Africa and in the world, because that is the first time where a former president was judged and sentenced for crime against humanity. So, but in Chad, it has created a mixed sentiment of satisfaction, and some of Hissène Habré's supporters were, after his death, beginning to ask for his rehabilitation, as I said. So, you know, the political situation in Chad is so complicated that this new event has put some kind of threat on lawyers and human rights activists in Chad. But for my part, I would say that working on such a case is a big challenge, because for me, for example, it's the first time that I have to face international criminal law in practice. It was great experience made of mix of fear, frustration, sacrifices, but also of pride. In Chad, those who believe in the fight against impunity consider us lawyers and human rights activists that work on the case as heroes, but a minority shows contempt mixed with jealousy. The success of the trial has galvanized population, and more people have come out to speak after the trial. This clearly shows that the trial is a stage of a much more global process of reconciliation, which needs to be put into place. But really, the biggest challenge that we face now is to get reparation for victims, because they are dying one after another while time is passing. But yeah, I will stop there and maybe take questions. Thank you.
Thank you so much, Delphine. I know I have a lot of questions for you once we get to the end of it. And you've really framed this so thoughtfully about both your own experience and what this means for Chad even today. But we'll turn next to read Brody, who is both a graduate of our law school, but has also spent decades around the world working for organizations, including Human Rights Watch, to bring accountability for mass atrocities committed by many political leaders around the world, and played a very central role in working with the different victims groups and to bring about this trial. So I'll turn it over to you, Reid. Thank you.
Hi, thank you very much. I'll jump right in because I know we're time sensitive. So Hissène Habré, as we've heard, was actually prosecuted 25 years after he left power. And the advent of the trial was really due to the perseverance and the tenacity of Habré's victims and people around them, like Delphine, who's on this panel, who created the political conditions to allow that trial to take place, but also who shaped the trial itself, and who participated in the trial as not just as witnesses or as observers, but as protagonists. And there was a group of victims, Souleymane Gengeng, a former prisoner who took an oath in prison that if he ever got out, he would fight for justice. When he was forced by Habré's threats from Habré's people into exile, his role was taken over by Clément Abaye-Fouta, who as a prisoner was forced to bury hundreds of his co-inmates in the mass graves. There were people like Jacqueline Moudaina, the lead lawyer, Delphine's good friend, who was the victim's lawyer, who barely survived an assassination attempt by Habré's victims. And these people drove the whole process. So they filed the case first in Senegal. When the case was thrown out in Senegal, they filed the case in Belgium. When the Belgian law on universal jurisdiction was crumbling and the case was hanging on the thread, they went to Belgium. Souleymane Gengeng, who I mentioned before, looks the Belgian officials, the prime minister, the justice minister, in the eye and says, "You can't abandon us now." And it was through these experiences that throughout Africa and particularly French-speaking Africa, people became familiar with this case, and they created the momentum. When there was a decision of the International Court of Justice in a separate case that suggested that former presidents like Hissène Habré might have immunity, it was our colleague from Chad, Dobion Assingar, who convinced the Chadian government to waive Hissène Habré's immunity. So it was one step, each obstacle, the victims and their team found a way to overcome those obstacles until finally this trial, Senegal was forced to hold this trial. And then at the trial itself, as one scholar put it, the victims handed the case to the tribunal on a silver platter. By the time after working on this case for 15 years, we had gotten to trial, we had interviewed hundreds of witnesses. We had uncovered, as Sharon mentioned, the documents of Hissène Habré's political police. We had the roadmap. Obviously, the court, as it prosecuted Habré and carried out its own investigation, but the contours of that investigation were shaped by the victim's narrative. This was not a distant prosecutor in The Hague who said, okay, let me see how I can get a quick conviction. No, the victims insisted that the Muslim victims, the Christian victims, the Zahawa victims, the HRI victims, the victims from the South, all be taken into account. And you know, this trial, we were very afraid when the court was set up that this could be a never-ending Milosevic kind of a trial where, you know, but this court, fortunately, in a way, had a very small budget of $10 million and a very limited timetable of 3 years. And so it was forced to do this work. And we gave them, through this 10 years, 12 years of work that we had done, a roadmap to do that. And the victims, because it was under the French civil law system, were partie civile. Delphine was one of the lawyers in that case, interrogating the witnesses, presenting evidence. And that made it ensured that the trial looked like something that the victims wanted it to look like. And so many of the victims came to testify. I remember in particular one woman, Kaltouma Defala, who had been sent as a sexual slave to serve in Hissène Habré's army, who testified, who looked at Habré and said, today I feel so proud because I am testifying today before the man who was powerful in Chad, and now I am powerful and he has to listen to me. And I think that was, you know, a very powerful sentiment that many people felt. And so when the trial, when the verdict came down, it was very much the verdict that Delphine and Jacqueline and Suleiman and Clement and I would have imagined 15 years before. And I think this shows the big difference between a victim-driven case and a case that comes from the outside. And this case, I'm just gonna, one last, this case was specifically, when Delphine came to me 25 years ago, Delphine, you know, this was during the Pinochet case. And Delphine said, we have a Pinochet, we wanna do what they're doing. And now other people around Africa, Jacqueline and I were in Gambia, other people are looking and saying, we wanna do what they did. And they can, because this is in our hands. It's in the hands of victims and civil society. Thank you.
Thank you so much, Reid. And goodness, you all are also incredible on timing. You're making my job very easy. That was incredibly moving just to hear about all the different pieces of this puzzle that came together. We have one more person to hear from before we take questions. Dr. Ndeye Amy Ndiaye is a lawyer who has extensive expertise in international law and in particular with gender. She's also a lecturer at the Institute of Human Rights at the University of Dakar. And during this trial, excuse me, she was a lawyer with the extraordinary African trial chambers. I'll hand it over to you. Thank you.
Good morning, everyone. It's a pleasure for me to participate at this panel. And thank you for inviting me. Thank you, Sharon. It's a pleasure. And Reid, hi. Delphine, hi, everyone. It's a pleasure for me to assist at this panel with Sharon and Delphine and Brody. Sarah, thank you for inviting me. The Habré trial in Africa contribution to international criminal justice. The conviction of former Chadian President Hissène Habré has been highlighted as a milestone for justice in Africa. It is a historic example of leadership in promoting accountability for international crimes at the regional level. The contribution of the extraordinary African Chamber to international criminal justice is now an undeniable reality and constitutes a new paradigm in international criminal justice in Africa, attesting to Africa's significant contribution to global efforts to fight impunity. We will attempt to make some points that we feel are important to consider as part of the important contribution of the Habré case. The Habré case redefines the place of civil law in international criminal justice. Usually, international trials are conducted according to common law principles and rules. The trial of Hissène Habré took place in an environment of Roman Germanic tradition, yet it generally respected international standards. The institution of the civil party allowed victims to participate in the trial on the same basis as the accused and the prosecutor. Secondly, the investigation phase conducted by independent judges has ensured an impartial investigation and speedy proceeding. The recognition of the right to reparation is also a significant element in the Habré case. Individual victims were entitled to reparation. The trial of Hissène Habré has shown that Africa is not a land of impunity. That is another point. President Hissène Habré, who committed crimes in Africa, was tried on African soil by Africans and sent to the commitment. The trial of Hissène Habré demonstrates the political will of African and judges. When there is a political will, of course, the judges render justice for international crimes. Also, the trial contributes to the development of international criminal justice from a regional perspective. I think that is the most important point. The trial of Hissène Habré has contributed to the development of international criminal justice through a regional approach. With the creation of the extraordinary African chambers, the continent asserted its sovereignty over its judicial effort. The extraordinary African chambers were certainly not the first criminal institution created in Africa or for Africa. There had already been the creation of special panels for crimes in Sierra Leone, but in that case, as in many others, the United Nations was involved in their creation. The extraordinary African chambers remain a truly African system. A specific universal jurisdiction, that is another point of contribution of the EAC jurisdiction. Because for the first time in the field of international criminal justice, a special court has been created to exercise universal competence. This jurisdiction is usually a state jurisdiction. The extraordinary African chambers, however, were not established to exercise Senegal's universal jurisdiction, ce qu'on appelle compétence universelle, on a permanent basis. Rather, their jurisdiction was established on a ad hoc basis. At the same, we can say the example of the most successful international criminal trial on African soil is the trial of Hissène Habré, which can be likened to a trial between Africa and international criminal justice. The positive impact of the Hissène Habré trial can be seen from the dual perspective of its fight against impunity and its participation in the progressive development of international criminal and or regional justice. This analysis shows that, contrary to what Christophe Châteauneuf predicted when he considered the conviction of Hissène Habré is a precedent without a future, this trial has a concrete impact on the future of Africa. The Habré's jurisprudence could be applicable in other situations. A hybrid tribunal has just been created in the Central African Republic. And read now, the victims of Ndeye Amy are also organizing themselves with the help of human rights and other institutions. The victims are organizing themselves to sue their former president, not forgetting the process initiated in Malabo, namely the Malabo Protocol. Thank you, everyone.
Thank you so much. That was so fascinating. And to all of you for such fantastic and interesting interventions here. You've really brought this case to life, and we're so lucky to have people who have participated in different ways. I'm reading some of the questions as they come in. I have about a dozen of my own, but apparently that is not what moderator priority actually means. So I will try and summarize a couple of them, but maybe just to sort of put us all on the same page. And I should say just at the outset, as someone who's litigated police brutality cases in the United States that take well over a decade just to get accountability against one officer for one individual, I'm really struck by what a mammoth effort it was to have this transnational activity with so many different actors, so many different victims with different claims, and the fact that the outcome sort of represents that diversity is really incredible. I think everyone would appreciate just to hear from any of you where things stand now in terms of reparations. Obviously, Habré is dead. Many indeed of the victims who participated in the case are now dead. I see a question here in the chat specific to this from my colleague Beth Van Skok about where Habré's assets are and whether Chad has agreed to render them to the victims, or will the government attempt to absorb them itself as the results of public corruption. If anyone would like to take that.
Delphine?
Vas-y.
So Habré's victims actually have two potential sources of recovery. They have a judgment in a Chadian court against the Chadian government for like $120 million, and they have a judgment against Habré in Dakar for like another $120 million. So they're millionaires on paper. The African Union has has a trust fund that was part of this whole process, that 4 years after the end of the appeals process has not yet been set up. But Habré's death, as Delphine mentioned, Habré's death triggered a renewed interest. I mean, Delphine and Jacqueline and I have not stopped working with the victims to try to get their money. And the African Union actually was in Chad last month to begin to set up this trust fund, which the African Union has already given $5 million to the trust fund. We suspect that Habré has hidden assets that the trust fund needs to start going after, and the trust fund plans to hold a donors conference. But it's a process, and these victims, as Delphine mentioned, are very poor, and many people have died since the verdict without getting their money. So for the victims, it's a bittersweet experience at the moment. I mean, I always believed, I should say, that the primary party responsible for paying the victims was the Chadian government. Their recovery should not depend on whether Hissène Habré survived long enough to face trial. But the process now is that there's this trust fund. The Chadian government has said last month that it would also pay in to the trust fund. So there will be some recovery for the victims, but it's taking much, much too long.
Maybe I'll take my pejorative back and ask Delphine in particular question, but I'm sure many of you have other reflections. You know, I'm curious, obviously this trial took place in Senegal, not in Chad, and I understand that it was recorded and people were able to watch it from Chad. I wonder, given that the trial didn't actually take place in Chad, what has been its impact in terms of strengthening rule of law or developing the justice system in Chad? Has it had positive reverberations, or has the fact that it didn't take place in Chad had some limitations in your work?
You know, the fact that the trial took place in Senegal was a choice, because the political and security environment in Chad did not allow such a process to take place in Chad, because you remember that the dead president of Chad was close collaborator of Hissène Habré, And as such, if Hissène Habré came to be trialed in Chad, nothing can guarantee its security. That's the first big reason for us to advocate and add this process outside Chad. We wanted a process that is neutral, that is clean, and that is transparent enough, and this political situation in Chad won't allow that. Now about the impact, I think that the fact that the prosecution was reported in televisions and radios allow people in Chad to follow the process step by step, and that was a very good thing. So everybody, when the verdict came out, the impact is that at that time, many people come out to speak and to tell their story. So not all the victims have been in Dakar, and that's why we think that now that it happened, it should be a milestone to start a bigger process to allow people to talk and to go for reconciliation process. On the side of law, we have also the former DDS officials that have been trialed inside Chad and also sentenced. So people are aware that such a situation could not remain, ne peut pas rester impuni, could not be, someone could not walk away with those kind of facts, and that is really a good thing. And it is a good precedent that a president of a state is trialed and sentenced. So I think there is an impact out there. And now with the situation in Chad, people are starting to want this process to happen about the human rights violation that occurred under the dead president of Chad. And I think that the Hissène Habré case has a lot to do with that. People trust that it's something that is possible. Yeah.
Thank you so much. We have many more questions in the chat, so I guess I will put off my follow-ups for now. But one from Natasha Fain about the courageous testimony of women survivors, and indeed that comes up very clearly in the book, I think in so many of the chapters, Sharon. She mentions that she's interested to hear about their voices, and could one of you speak to the experiences during and after the trial? These were pretty novel claims at the time. If any of you wants to take that.
Delphine?
Yes, if I can answer about the amicus brief, and then if other want to speak about the testimony. So, you know, I mean, it's Kim Seelinger from the Human Rights Center in Berkeley. So she's one of the editors of the book. So of course, it was very important for her to bring also the aspect of sexual violence into the book. So because of the lack of time, maybe the best thing that I can do is just to refer you to the book, because they wrote an excellent chapter about this entire process of writing the amicus curiae, because there is one thing about the law and what the law is, but it was not evident also to submit an amicus curiae for the court, because there wasn't a procedure about this. I mean, in the statute, you know, it wasn't something that was clear how to do. So it was a little bit a process, a creative process. So this is about the amicus curiae in itself, and the author of the amicus curiae wrote a chapter on this. Then we have several chapters of sexual violence, and then of course there was this important testimony that we had in court about the direct rape of Habré against this victim that testified. And I think this is the beauty of victim participation in trial. That, I mean, in France, this is how trials are in civil law system, right? So you have the victims that come there as a civil party, as Reed said, And things happen in the hearings, you know. It's not like a very structured procedure as in common law. And then you can have new even facts that emerge and new story that arrive here because this is the procedure. However, at that time in the Habré, there was an issue to accept this testimony because of the adversarial component of it, so they couldn't accept at the end the testimony, but it was a very strong moment of the trial.
Yeah, I could add that those women are really heroes, and their courage needs to be acknowledged, because we are in Chad, in Africa, where sexual questions are taboo, and those women were testifying openly, and they were seen by their families. Some have renewed their life, so their husbands are out there, but they take this opportunity really to testify and to tell Hissène Habré that they are proud, and they are now talking to the men that have making them suffer. And I can remember one of them, Khadija, who accused Hissène Habré of raping her personally. She was so brave to go into details on how that happened. And even one of them, Mariam, who was arrested when she was only 12. So she was also deported along with her mother. So it takes something to come out and speak about something that you have suffered like intimately. So I think that it gives more victims of rape to come out and speak. I'm working on violence against women and girls, and I can see that there is a big move that women can come to us and say, I was raped by such and my girl was raped. Such a thing have never happened before, because it is taken as a secret matter to cover the honor of the family, and nobody can know really that there are some kind of things that are happening in families. Now we have more than 20 girls under 18 that have been raped, and we are handling those cases. And I think that the Hissène Habré case has a lot to do with this, because women have started to speak and they gave courage to other women to follow. Yeah.
It's incredibly inspiring. It must have been incredible to be a part of it. Dr. Ndiaye, I think there's a couple of questions that seem like they might be up your area of expertise. Maybe you could start with the first one from Margaret Jewett about whether there are some aspects of the civil party system that were sort of integral to the success of the Habré trial that could be incorporated into other international criminal trial proceedings. For example, the ability of victims to participate as civil party plaintiffs.
The institution of the civil party, for example, is allowed the victim to participate on the trial on the same basis as the accused and the prosecutor. That is a case we do in the civil law, the civil party, and that was on the EIC, Extraordinary African Chamber. We allow the victim to participate on the trial on the same basis as the accused and the prosecutor. Secondly, the investigation phase, because the we call that in French chambre d'instruction. The investigation phase conducted by independent judge has played a key role in the investigation of the charges. That has ensured an impartial investigation, speedy proceeding, and that make it much easier for the judge to hear the case on its merits when faced with an accused who has opted for silence. The President Habré refused to respond to the judge. But because of the procedure, the investigation phase, the judge can continue the procedure and can continue the investigation. So that is also a good practice of civil law. The recognition of the right to reparation is also a significant element in the Habré because individual victims were entitled to reparation. The total amount awarded to direct and indirect victims who suffered from certain categories of offenses is just over 82 billion CFA francs. We think that the prices of civil law are very good, and we can share that on the international criminal justice. In the international criminal court, we do victim participate to the debate, but at the extraordinary African chambers, victims are more possibility to participate. Delphine can explain that the victims are a big plus as the international, as the extraordinary African chamber, and we can share that. We think that is very good things. And the investigation phase. In the civil law, there are investigation phases. The judge participate to search the truth, and that is good, and that can be shared with international justice. Thank you.
So interesting. And did you want to also address this question about the Malabo Protocol, as I know that's also was in your presentation?
Malabo Protocol does not have a direct impact on the trial, but the trial itself has given Africans more confidence. Do they know that they can resolve criminal justice issues on African soils? Get there, and that it is important to implement international criminal justice from a regional perspective. We think on this way, the Malabo Protocol have a link with extraordinary African chambers. Thank you.
Thank you. We have just a few minutes left, so I think maybe I will ask a final question, if you don't mind. I feel this American obligation to end on a positive note, and yet I'm going to ask something a little more challenging. Excuse me. I think around the world, there's maybe a lot of ambivalence right now with the efficacy of international tribunals, international criminal law more generally. I think you've all spoken, particularly in the beginning, about how important it was that this was an African court and how it really was able to address impunity. But of course, you've also spoken about the fact that reparations haven't yet been paid out to the victims. I should say, I don't think this is a problem that's unique to international courts. I've worked on plenty of trials in the United States that took a long time and were ultimately, there was a lot of impunity and victims didn't get the type of justice that they needed to see in court. But I'm curious, just sort of thinking about the efficacy of this particular tool of using international law and using an international tribunal. Do you have any reflections, and are there other potential lessons for states or communities that are looking to hold abusive leaders accountable, given some of these limitations?
Reid, I think you should answer perhaps this question.
Well, I think there are different kinds of international justice. I mean, the International Criminal Court has been around for almost 20 years. It's spent almost $2 billion, and it's never actually convicted any state official. So I would, on the other hand, you look around the world and you see a lot of exciting things happening. In whether it's Guatemala or this week the trial of the killing of Thomas Sankara began in Burkina Faso, and you have a lot of national but also international trials. I mean, you have the trials of the Syrians in Germany. You have, thanks to, again, most of these thanks to the work of victims and activists, people like Civitas Maxima in Switzerland, or the Center for Justice and Accountability in San Francisco, who actually do international justice on the cheap and do it in a way in partnership with victims, in partnership with activists, in a way that means something. So, I mean, you look at this trial cost $10 million, which, to the average person is a lot of money, but it really isn't in these things. And it was done very quickly. And it, again, aside, I mean, I don't think, I come from an American background where reparations are over here and criminal trial is over here. So, I mean, because I've worked with the victims for 20 years, I understand that their expectation that this was, and we're working on it. But, I don't think we should judge the Habré trial by the fact that there wasn't reparations. The government of Chad that should have always been paying reparations. So I think, you have, but I think it's also, as they say, it's everybody wants to bring people to international criminal justice only works in certain circumstances. And it's not the tool of choice in every circumstance.
Can I add something, Sarah?
Please do.
Yeah. No, I completely agree with Reed, and maybe I will also answer one of the questions about the independence and etc. So to continue the point of Reed, it's, in order for a trial like this to happen, which are very political trial, of course, you need a certain political momentum for them to happen. So of course they won't happen every day. But I think that today in many, many states, we have the legal structure that we didn't have before. Even in Senegal, you didn't have the universal jurisdiction, and today you have. So in many states, you have the structure. In law school, we teach very naturally this discipline. When I was a student, there wasn't this discipline. So we need to take, this wider look on the area. And as Reed said, so you have trials that are at national level. You have those at hybrid level, like in Colombia, what we have today. You have those at international level. And I don't think it's like who is better, who is worse. It's just everything is international criminal justice, right? And the effort are being done in all the possibility that we have. And this is what NGO are doing. Sometimes they succeed, sometimes they're not, but it's ongoing.
Well, thank you both. And I think thank you to everybody for joining this panel. You've ended on the appropriate note and giving us a lot to think about, and obviously also well-timed because it's right before my human rights litigation class where we're discussing just this topic. But thank you all so much for sharing your wealth of personal experience. It's so humbling to have individuals who are so critical to this really important trial that was, yes, definitely something that set a precedent, but also it sounds like really was an important experience for all of the people who were involved in it. And often that is the best outcome or the most impact that you can have in a trial. So I think I encourage everyone again to read this fantastic book. You will learn so much from it. It will help you as a researcher, will help you as a lawyer and a litigator. Thank you again to all of our panelists, and thank you to our audience for joining us today. We really appreciate it.
Thank you.
Thank you, Sarah. Thank you for organizing.
Thank you, everyone.